Good afternoon to all my dear friends. As you know that I am taking second class on the landmark judgment, that is the Vijayasinh, Chandubha, Jadeja and another versus state of Gujarat and other. And this is the landmark judgment on section 50 of the NDPS Act. Basically, section 50 of the NDPS Act talks about the some procedures, and that procedure has been enacted to protect innocent persons from the capricious and whimsy minds of the police authority. That's why in several judgments, Supreme Court has clarified that provision of Section 50 is the mandatory. As you know that in the previous classes, I told you that there are near about the 7 cases which are very essential to discuss on this point regarding the state of Punjab and versus Baldev Singh case and Vijayasinh Chandubha Jadeja case. These 2 cases have been decided in the by the constitutional bench, and everyone knows that what was the need, why the constitutional bench was bound to decide this case. The reason was that there was some controversy among several benches of the High Courts and Supreme Court. That's why constitutional bench interpreted the section 50. First time constitutional bench interpreted this section in the case of Baldev Singh versus Baldev Singh case. My point is that whole section 50 revolve around to section 50 revolve around to Baldev Singh case. It means the most important and landmark judgment on the section 50 is that स्टेट ऑफ पंजाब वर्सेस बलदेव सिंह केस. ये एक पहला जजमेंट है और सबसे इंपॉर्टेंट जजमेंट है जब कॉन्स्टिट्यूशनल बेंच ने इस पॉइंट को डिसाइड किया है, तो इस पॉइंट को हमें ध्यान में रखना होगा. एंड अनदर लैंडमार्क जजमेंट इज दैट विजय सिंह चंदुभा जडेजा लाइक दिस. एंड लास्ट केस इज दैट आरिफ खान वर्सेस स्टेट ऑफ उत्तराखंड. I have quoted this case, last case, only for 2 purposes. As you know that this is the most recent judgment on the section 50. As you know that I was reading some recent judgment of the Delhi High Court, but that was the judgment of the Delhi High Court. That's why I did not feel comfortable to quote. And this is the most recent judgment of the Supreme Court on the point of the section 50. That is the name of the case, Arif Khan, alias Aga Khan versus state of Uttarakhand. And now I will discuss, first of all, I will discuss which questions we have to discuss and which types of questions they have been asked in the previous semesters. The point is that come to the read what is the previous year question paper. Previous year question paper was that a police party was proceeding from Gokulpuri to Bhajanpura on patrol duty in a jeep. This is a similar fact to the Karnal Singh case, but don't mix either and either, because main point here is that we have to concentrate on this particular fact. Our concentration should be on this particular fact rather than other. The point was that a police party was proceeding from Gokulpuri to Bhajanpura. This area is in the Delhi. Gokulpuri to Bhajanpura on patrol duty in jeep. On the way, they stopped T. T means you can take name of the any person. Suppose that T means Tripurari. You can take example that they stopped Tripurari who was coming on foot carrying a plastic bag in his hand. T police party apprehended. I think here there is a some minor mistake. I think I should have made the correction. Please note down. I have to make the correction here. Police party apprehended T being suspicious to him. Immediately, police inspector searched T without 1 minute. Please wait 1 minute. I say without saying anything and recovered large quantity of opium from the bag. It means this was a clear-cut violation of section 50 because there are 6 clauses. There are 6 clauses of section 50. According to the first clause clearly says that before searching any person, you are bound to inform that you have right to choose either to make the search from this police authority or you can request, or you can have a choice to go in front of the magistrate or gazetted officer like this. Main problem was that in this case, immediately police inspector searched Tripurari without saying anything. This is the core point. Without saying anything, and recovered large quantity of opium from the bag. Tripurari was arrested and put under trial, where he took the defense of non-compliance of Section 50 of the NDPS Act. As you know that even the prima facie reading of the question, it becomes very clear that here the police authority has violated the Section 50, and that's why his conviction of Tripurari was illegal, not sustainable, and even whatever was seized from the possession of the Tripurari, that was also the illegal. So my point is that you have to answer this question, but how to answer in the semester exam? Here I have write only brief. You can write in this, say in this problem, several provisions and cases are involved, but at least Section 50, State of Punjab versus Baldev Singh, Vijayasinh case versus State of Gujarat, and Arif Khan versus State of Uttarakhand must be discussed thoroughly. It means, as you know that here answers requires all the cases regarding the writing of the Baldev Singh, Joseph, Prabhas, Srimati, Krishna, Vijayasinh, Ari, but it is not possible within to write within 40 minutes each and everything. So that's why at least you have to discuss Section 50, ratio of the Baldev Singh case, Vijay Singh case, Arif case, like this. As you know that these two cases, that is the Vijay Singh and Baldev Singh case, Vijay Singh and Baldev Singh cases was decided on the basis of referred order. What is the meaning of referred order here? Here referred order means there was a confusion, there was a controversy on the point of the law, and to resolve that controversy, a smaller bench framed the question and referred to the constitutional bench through an order. That is called the referred order. So my point is that in the case of Baldev Singh and Vijay Singh, question was decided only on the basis of referred question. There was no question whether the accused was convicted or acquitted. But in the Arif Khan case, in this case, there was a direct question regarding the conviction or acquittal. And in the Arif Khan case, what happened? In the Arif Khan case, Supreme Court said that this was a single bench. Supreme Court said that ratio laid down in the Baldev Singh case and Vijay Singh case have settled down any disputes regarding the Section 50. And in this case, Section 50 was not followed strictly. That's why accused was acquitted. It means finally Arif Khan was acquitted. Why Arif Khan was acquitted? Because Section 50 had not been complied strictly. On this way, you can discuss all the legal points, and after discussing the legal points, you can write the conclusion. Conclusion is that T will be acquitted. Tripurari will be acquitted. Why he will be acquitted? The reason of this is that non-compliance of Section 50, which compliance were declared mandatory in above mentioned cases. In above mentioned cases, you can take the State of Punjab versus Baldev Singh, Vijay Singh case, and Arif Khan case. As you know that in semester exam, what happened? Several friends asked that, sir, I wrote very exhaustive manner, so many pages like this, but I did not get good marks, and the teacher did not evaluate it in the proper manner. There are several reasons. I am not denying that points, but sometimes what happened? Sometimes what happened that students do not write in a systematic manner. They write in such a mingle way that you can't understand what they want to say. वो करता क्या है, कई बार इतना कंफ्यूज रहता है कि दूसरे को भी इतना कंफ्यूज कर देना चाहता है कि वो समझ ही नहीं पाए कि मैं लिखा क्या हूँ और नंबर मिल जाए. ऐसे कभी नंबर नहीं मिलेगा. आप जितना क्रिस्टल क्लियर लिखोगे उतना ही आसानी से मार्क्स मिलेगा. इसीलिए मैं बता रहा हूँ, जैसे आपको कहता है ना कि नहीं हमने लिखा हमें मार्क्स नहीं मिला. किसी बच्चे का देखिएगा जिसकी राइटिंग स्किल अच्छी रहती है, वो फर्स्ट सेकेंड थर्ड फोर्थ सेमेस्टर सारे सेमेस्टर में ही उसके मार्क्स अच्छे आते रहते हैं. अब उसका क्या रीजन है? ऐसा तो नहीं है कि अगर वो कंटिन्यूअस अच्छा मार्क्स अगर पा रहा है तो टीचर उसकी कॉपी को आइडेंटिफाई कर ले रहा है और वो जान जा रहा है कि हाँ कपिल की कॉपी में हर सेमेस्टर में अच्छा मार्क्स दूंगा, ऐसा तो नहीं होता है। कहीं ना कहीं आप में एक राइटिंग फॉल्ट होता ही है। अभी हम लोग टेस्ट करवा देते हैं कि नहीं सब्जेक्टिव टेस्ट ही कर लीजिए, कोई बच्चा ज्वाइन ही नहीं करेगा। So this is the basic problems. It my point is that write in such a systematic manner that even writing 2 or 3 lines, he can understand what do you think. If you write by making the heading summary, for the example, I always write here like this. Here some heading is missing, some point there is some mistake. You can write here statutes, leading cases, and in here you can mention the conclusion. In the last, you can make a point here is that like the conclusion. Here I am unable to. कहाँ से नहीं आ रहा है? Oh, suppose that last point is that you have to want to write a conclusion, and in the conclusion you write only one line: T was acquitted. It means by merely the summary, a teacher can understand what is going on in your mind. This is the best method to writing in the competitive exam as well as semester exam. That's why in the very at least in the conclusion, always try to make a heading of the conclusion. In the conclusion, here I am clearly write that T will be acquitted. This is simple one line. T will be acquitted. And reason of this is the non-compliance of section 50. Even 1 or 2 lines clearly denote that what is going on in your mind. So my point is that you have to solve a problem in such a way. Now question start. What is the ratio of state of Punjab versus Baldev Singh case? What is the ratio of Vijayasinh case, and what is the ratio of Arif Khan case? As you know that I am taking the second class, that's why I am not going to discuss again and again section 50. Here there were section 52 parts, original part and inserted part. And according to the class 4, how to remember, it is my humble request. Please remember wording of the section 42, section 50, section 31A, at least 3 sections. By remembering the words of these 3 sections, you can get good marks. And it is not possible to remember the good marks, but once you determine, you can do. How to remember? This is the basic point. In any semester, if you want to remember any provisions, you can do. This is not a big problem. तो माय पॉइंट इज दैट मैं अभी आपको कहता हूँ कि मैंने 22 में से लिखा जुडिशरी में, अरे 21 में सिलेक्शन नहीं हुआ, 21 में सिर्फ इंटरव्यू में लिखता था, होता ही नहीं था। जब मैं बनारस गया तो वहां पे एक मेरा बैचमेट था, हिंदी मीडियम का था, उससे जब मेरा डिस्कशन शुरू हुआ तो कॉन्स्टिट्यूशन का बेयर प्रोविजन याद था, कोई बहुत बड़ी बात नहीं है, कॉन्स्टिट्यूशन का हर कोई याद कर लेता है। उसने यहाँ तक कि ट्रांसफर ऑफ प्रॉपर्टी के भी सेक्शन याद रखा, उनमें याद कर रखा था कि अगर सेक्शन 43 है, सेक्शन 41 है तो क्या कहता है, मतलब एकदम वर्डिंग याद था उसको। तब मैं लग गया कि नहीं, बिना रटे हुए काम नहीं चलेगा, और मैंने भी अपना माइंड फ्रेम कर लिया कि नहीं, मुझे भी बेयर प्रोविजन रटना ही है। फिर मैं उस टाइम रटा, उस महीने में 1-2 महीना रटा, इसके बाद एटलीस्ट इंटरव्यू में फिर पास ही कर गया, मतलब इंटरव्यू ने मेंस में क्वालिफाई कर गया। तो हमारे कहने का मतलब अगर माइंड में एक बार डिसाइड कर लो कि हमें रटना है तो रटा जाएगा, ये माइंड का गेम है और कोई बहुत बड़ी बात नहीं है। फिर भी अगर बच्चा नहीं रट सकता है तो उसके लिए क्या प्रोसीजर है, मैं हेडिंग बनाया हूँ, 5 पॉइंट याद कर लेना तुम लोग। क्लास फर्स्ट कहता है ड्यूटीज ऑफ अथराइज्ड पर्सन टू इन्फॉर्म। अब ड्यूटीज से बहुत ही क्लियर हो गया कि पहला क्लास क्या कहता है कि पुलिस ऑफ अथॉरिटी इज बाउंड टू इन्फॉर्म दैट दिस इज योर राइट, and after the information, suppose that I am police officer and Kapil is the accused. According to the class 1, it is my duty to inform Mr. Kapil, you have 2 options and these are the options. And class 2 says that whatever I have told, my time is over. Now game is in the hand of the Kapil. Second class talks about the Kapil, what Kapil can do. Kapil has an option. If Kapil said that yes, yes, Mr. Murari, you have to produce me before the gazetted officer. I have not faith upon you because you are part of the police department and you can misuse your power. That's why I am not interested to search by you. That's why produce before the gazetted officer. The first point my that this point class 1 talks about the police officer. Second point talks about the suspected person, that is the Mr. Kapil, and the third person is that As you know that once Mr. Kapil choose, please produce me before the gazetted officer or the magistrate officer. The, on that he will be produced. Once he is produced, wait. Once he is produced, what is the duty of the gazetted officer? Suppose that I am the police officer. Here, this is the Kapil second part, second Kapil. Third part talks about the path. Suppose that path is the gazetted officer or magistrate. It means that what is the duty of the gazetted officer? Because he will be produced before the magistrate. Third class talks about the duty of the path, duty of the gazetted officer or magistrate. In these circumstances, you have to class 3 talks about the two options. If there is a reasonable chance, reasonable grounds that Mr. Kapil has committed the offense, Mr. Parth, that is the gazetted officer, will give direction. Yes, Mr. Murari, search him in front of me. And second option for the gazetted officer is that if there is no reasonable grounds that Mr. Kapil has committed any crime, he will immediately discharge the Mr. Kapil. The first class, Mr. Murari, second class, Mr. Kapil, third class, Mr. The Parth. And fourth part talks about, for example, Shivani. There are two, suppose that there are two girls, one is the Muskan and other is the Shivani. Here the Shivani is the criminal and Muskan is the officer. The my point is that, and here I am also police officer. Question is that who can arrest Shivani? Whether Mr. Murari can arrest or only Miss Muskan can arrest. According to the class 4, although Mr. Murari is also the police officer, authorized under section 442, but he can't arrest Miss Shivani. Why he can't arrest? Because he is not the female. According to the class 4, only female can arrest another female. The point is that no female shall be searched by anyone excepting a female. The point is that class 4 talks about the two types of female. One female, that is the suspected criminal, and another female, that is the police officer authorized under section 42. The point is very clear. Class 1 Murari, class 2 Kapil, class 3 Parth, class 4 Shivani and Muskan. Come to the class 5. As you know that class 5 were inserted in 2001. Two classes were inserted. Class 5 and 6 were inserted at the later on, that is in the 2001. What happened by these provisions? If you read the case of the Jadeja, whatever I will discuss, in the Jadeja case, object of class 5 and 6 were discussed. Later on, I will discuss what was the object, why class 5 and 6 were inserted in section 50. Object of insertion of this section, these classes were discussed in the Jadeja case. That is the Vijayasinh Chandubha Jadeja versus State of Gujarat case. Class 5, what is the class 5 and 6? My point is that why these were inserted, reason was that class 1 was very strict. What was the problem? Suppose that class 1 and class 2, if person choose that please produce me before the gazetted officer. Suppose class 2, according to the class 1, Murari will ask. Class 2, Parth has option. Suppose that Parth say that Murari, you can't touch me. Produce me before the gazetted officer. And this is going on in the forest area. Or these are going on in the remote area. In the remote area, there is a lot of chance that once Murari will try to produce the Kapil in front of the gazetted officers, who is sitting just 200 kilometers away, what would be happen? In the journey, Kapil may throw out the charas, and it will be not possible to search in front of the magistrate. It means circumstances denotes that there is a lot of chance that during the journey, at the time of producing the gazetted officers, suspected persons may throw out the prohibited drugs or substance. In that case, what will be procedure? Actually होता क्या था, इसमें ये प्रॉब्लम आती थी कि जैसे ड्रग्स के अकाउंट होता है, जो एलएसडी है, उसकी मात्रा 50 ग्राम बहुत ज्यादा हो जाएगी। 50 ग्राम 100 ग्राम मतलब 2 लाख 4 लाख का एलएसडी हो जाता है। जैसे मिस रिया चक्रवर्ती के केस में जो मैटर चल रहा है वो एलएसडी का ही है, उनमें अफीम का नहीं है, उसमें एलएसडी का डायरेक्ट है, बहुत ही उस तरह का मैटर होता है। अब अगर क्लेम कर दे रिया चक्रवर्ती कि हमें आप मजिस्ट्रेट के सामने प्रोड्यूस करिए, तो चलिए कि मिस रिया चक्रवर्ती के मामले में बॉम्बे में पुलिस गजेटेड ऑफिसर था, सब कुछ नजदीक था, सही है। अब मान लीजिए कि पालगांव में एक पहाड़ी एरिया में किसी व्यक्ति पर डाउट हो जाए, अब वहां पर उसको ये कहा जाए कि तुम्हारे पास ये ऑप्शन है, वो कहे ठीक है हमारे पास ऑप्शन है, तो चलो मुझे गजेटेड ऑफिसर के पास ले चलो, उसी के सामने मुझे सर्च करना। अब गजेटेड ऑफिसर कहाँ बैठा हुआ है, 100 किलोमीटर की दूरी पर बैठा हुआ है, और इतना पहाड़ी एरिया है, इस तरह का रिमोट एरिया में है, उसको रास्ते में लाते लाते उसको 4 से 5 घंटा लग जाएंगे। और हो सकता है कि थोड़ा सा अगर कहीं पर अगर मिसअंडरस्टैंडिंग हो तो तुरंत जीप में बैठे ही पहाड़ी से नीचे फेंक देगा। देखते हो ना पहाड़ी एरिया में कितने खाई में जाती है, मतलब ऐसे ऐसे कट कट करके जाती है गाड़ियां, वो फेंक देगा। आप मजिस्ट्रेट के सामने प्रोड्यूस करके भी क्या करोगे, मजिस्ट्रेट भी डांटेगा कि तुम इनोसेंट आदमी को तुम अरेस्ट करके क्यों ला देते हो, इसके पास तो कुछ मिला ही नहीं। इस तरह के प्रॉब्लम को सॉल्व करने के लिए क्लास 5 लाया गया। क्लास 5 का मैंने हेडिंग ही बना रखा है, जितना हेडिंग है मैं खुद इंसर्ट किया हूँ, ये बेरट का वर्डिंग नहीं है, बाकी वर्डिंग बेरट का है। जैसे क्लास 5 कहता ही है कि रिलैक्सेशन इन क्लास 1 एंड क्लास 2, इसको अभिषेक इसको यहाँ नोट डाउन करना, तो क्लास 1 एंड क्लास 2 लिखना पड़ेगा यहाँ पे,
जी
यहाँ पे
सर।
क्लास, हाँ इसको वो करना है, यहाँ पे क्लास 1 ही नहीं रहेगा, क्लास 2 भी रहेगा, क्लास 2 3 दोनों में ऐड करूंगा। रिलैक्सेशन इन क्लासेस, रिलैक्सेशन इन क्लासेस 1 to 4 कर देंगे इसको, relaxation in classes 1 to 4 and search under section 100. So what is the section 100 of the CRPC? According to the section 100 of the CRPC, police officer can search place in presence of the two witnesses, and two witnesses can be anyone is generally reputed person of the village. तो उसमें क्या होता है क्लास 100 के अंतर्गत कि गांव के किसी भी 2 आदमी को बुला कर खड़ा कर देते हो, जैसे गांव में कुर्की होती है ना ड्यूरिंग द अटैचमेंट ऑफ द क्रिमिनल्स, तो इन सच टाइप सर्कमस्टांसेस में 2 गांव के जो रेस्पेक्टेड आदमी होते हैं उनको बुला करके लाते हो और उनके सामने आप सर्च कर देते हो, और वहां पे किसी गजेटेड ऑफिसर को ले जाने की जरूरत नहीं है। तो माय पॉइंट इज दैट क्लास 5 सेज दैट there is no need to produce before the gazetted officer or magistrate. Even the presence of 2 witnesses are sufficient to make her or him personal search. Okay, this is the class 5. But class 5 is the second conditional. There are 2 parts of the class 5. First part is the condition. If first part, that is the condition, are not being fulfilled, you can't use the class 5. So what is the condition? Condition is that when the officer duly authorized under section 14 has reason to believe, has reason to believe is directly related to the class 6. Has reason to believe directly related to the class 6. Reason to believe that it is not possible to take the person to be searched to the nearest gazetted magistrate without the possibility of the person to be searched parting with possession. Parting मतलब अपने आप को अलग कर लेना, उस चीज से सामान को फेंक देना, इस तरह की चीजें जो होती है पार्टिंग कहलाती हैं। कह रहा है कि अगर यहाँ पे पुलिस ऑफिसर को सर्चिंग अथॉरिटी को रीजन टू बिलीव हो, there is a big difference between believe and reason to believe. I say that Kapil is a worst person. This is my belief. But I say that Kapil is a worst person in the class because his writing and understanding skill is not good. His writing and understanding skill is not good, come under the category of reason. And belief is that Kapil is not the good part. Good student. There are 2 parts. We are talking about reason to believe rather than believe. This is the basic difference between reason to believe and believe. Reason to believe. What is the reason to believe? That reason to believe you have to write the record the reason under class 6. This is a mandatory. What is the reason to believe? Reason is that it is not possible to take the person to be searched before the nearest magistrate. In that circumstances, police officer can use a search under section 100 of the CRPC. This is the very basic normal circumstances. And whatever on the basis of reason to believe you have acted, that reason you have to write. So my point is that there are 6 class. First class talks about duties of police officer. Second part, option to the suspected accused. Third class duty of the gazetted officer. Class 4 female by female. Relaxation in class 1 to 4 and research under section 100 and recording of the reason. These are the point. And in the case of the Jadeja case, Vijayasinh Chandubha Jadeja case, Honorable Supreme Court observed that why these classes were inserted, why class 5 and 6 were inserted. These are the reason of insertion of class 5 and 6. Reason was that flexibility. What was the reason? Flexibility, what was the object? Flexibility in procedural requirement in terms of 2 newly inserted subsections can be resorted to only in emergent and urgent situations. Only in emergent and urgent situation contemplated in the provisions and not as a matter of course. It means इसमें कहा गया था कि class 5 and 6 must be used as a medicine rather than a daily use. So my point is that class 5 is it can be used, can be recourse only in exceptional circumstances. In normal circumstances, class 5 can't be used. Why? Because it has been given some relaxation. Because purpose of law is that to make harmonious relation between right of accused as well as power of the investigating agency. Power of the investigating agency. In absence of class 5 and 6, it was difficult to make the harmonious relation between right of the accused as well as power of the investigation. Because class 1 to 4 clearly talks about the right of the accused. It was much more favorable in favor of the right of the accused. But it was not favorable for the investigating agency. And now class 5 and 6 talks about the relaxation and gives power in the hand of the police authority. It means we can say that class 1 to 4 favors accused suspected person and class 5 and 6 favors to the investigating agency. These are the basic points. These are the basic section 6. I hope that in 2 classes you have got what is the section 15. बताओ भाई, अगर किसी को सेक्शन समझने में प्रॉब्लम है तो मैं एक बार डिस्कस कर लूं. अगर सेक्शन समझने में प्रॉब्लम नहीं है तो मैं आगे बढ़ जाऊं. चलो आगे बढ़ जाता हूं. Now I have to discuss state of Punjab versus Baldev Singh case. This is the landmark judgment, and without knowing this particular case, you can't understand even the single word of the section 50. एक बार बता दूं, since decision of this particular case till now, whenever any question is discussed on the section 50, always state of Punjab versus Baldev Singh case is discussed. Always, like it is a mandatory. Here I have put here all the list of the some cases. If you see, in all the cases, Joseph, Prabha, Srimati, Vijaya, Arif, in all the cases, ratio of Baldev Singh was discussed. Even in the case of Vijayasinh Chandubha Jadeja, which is your syllabus, Honorable Supreme Court again repeated that whatever ratio has been upheld, has been laid down in the Baldev Singh case is the finest, and there is no need of the deviation. This is the perfect, and we are going to follow the same ratio. आपके विजया सिंह के केस में जब कॉन्स्टिट्यूशनल बेंच ने लगभग आफ्टर 11 years when case was decided in the Vijaya Singh case, Honorable Supreme Court again reported that whatever ratio has been discussed, that is the perfect ratio, and that's why in the Vijaya Singh case, Supreme Court summarized ratio in the ratio of the Baldev Singh case. एक बात और बता दूं, पढ़ने का बहुत आसान तरीका होता है. अब हम लोग इतना केस कैसे पढ़ लेंगे? सारा ओरिजिनल केस डाउनलोड करना होता है, पढ़ना होता है, बहुत ही मुश्किल होता है. डाउनलोड हो जाएगा, ठीक है, आसान काम है, लेकिन पढ़ना बहुत ही मुश्किल काम है. पढ़ने का एक तरीका होता है, क्योंकि अब देखो इस टाइम तो कुछ मटेरियल है नहीं, आपको कैसे पढ़ना है, कैसे समझना, उसी से नोट्स बनाना, उसी को पढ़ाना है. इसका एक तरीका होता है, जैसे मुझे मान लो कि स्टेट ऑफ पंजाब वर्सेस बलदेव सिंह का केस पढ़ना है. अब केस तो होगा इसमें कम से कम 20-25 पेज का, तो मैं 20-25 पेज कभी नहीं पढ़ूंगा. मैं क्या करूंगा, मैं रिसेंट जजमेंट कोई भी उठा लूंगा, कोई भी रिसेंट जजमेंट उठा लूंगा, और जो भी रेशियो का होगा बलदेव सिंह का, वो ऑटोमेटिक सारा रेशियो 1 by 1 लेट डाउन कर देगा. इस रेशियो का समराइजेशन जो किया गया था, बलदेव सिंह का समराइजेशन क्या है, हेडिंग क्या है, इसके रेशियो को जोसेफ केस में भी बताया गया था कि दीज आर द 7 रेशियो. प्रभाग केस में भी बताया गया था, श्रीमती कृष्णा केस में भी बताया गया था, और विजय सिंह के केस में भी बताया गया था. That's why I downloaded Vijaya Singh Chandubha case and wrote the judgment, and I got a ratio of Baldev Singh case in very easy manner. Okay. When I was interested to know the ratio of Vijaya Singh case. What was the ratio of Vijaya Singh case? I had two options. First option was that to read the original judgment of the Vijaya Singh case, and another option was that Arjit Khan versus state of Uttarakhand. I have two options. That's why, okay, I accept that I read whole the judgment of the Vijaya Singh case twice or thrice, but I also read the Arjit Kumar case. In the Arjit Kumar case, Honorable Supreme Court clearly said that these are the guidelines or ratio laid down in the Vijaya Singh case. अब हमें बहुत इजीली से विजय सिंह का रेशियो हमें यहाँ मिल गया, जोसेफ का रेशियो हमें यहाँ मिल गया. अब ये काम हमारे लिए बहुत ही आसान हो गया. इस तरीका होता है. इसीलिए हम लोग हमेशा चाहते हैं कि जो रिसेंट जजमेंट हो वो अपने बच्चों को पढ़ाया जाए, ताकि रिसेंट करेंट का पोजीशन हमेशा मालूम होना चाहिए, और आंसर भी तुम बेटर पोजीशन में लिख करके आओगे. बाकी बच्चे क्या करेंगे, बाकी बच्चों का ध्यान विजय सिंह पर ही रहेगा, लेकिन तुम्हारा ध्यान विजय सिंह पर नहीं होना चाहिए. तुम्हारा ध्यान बलदेव सिंह के केस पर सबसे ज्यादा होना चाहिए, बलदेव सिंह का केस. इसके बाद तुम विजय सिंह आओगे, और अरिजीत के केस के थ्रू से तुम इन ऊपर के केसेस को कंक्लूड कर दोगे. अब हम डिस्कस करेंगे व्हाट वाज द रेशियो ऑफ द स्टेट ऑफ पंजाब वर्सेस बलदेव सिंह केस. Para number 57 of that particular judgment discuss about the ratio of that case. But come to the point here. State of Punjab versus Baldev Singh case. State of Punjab versus Baldev Singh case में क्या था? What was the fact? Point was that fact was very simple, because there was a dispute among several benches regarding the interpretation of Section 50. That's why lower bench referred the matter to the constitutional bench, and constitutional bench decided the matter. In this case, constitutional bench decided the questions which have been referred to it. I have several times told you that what is the meaning of referred to. Whenever referred to word is used, it means that in that particular case, conviction or acquittal was not discussed. Only the disputed question was discussed. That is called the referred case. It means that this case was decided to clarify the provisions regarding Section 50 of the NDPS Act. This Act was decided to clarify provisions regarding Section 50 of the NDPS Act. हाँ देखो, तुम लोग और भी एक बात मैं बताना चाहता हूँ. तुम लोग की संख्या भी ठीक है, तुम लोग सारे प्रेजेंट भी होते हो, मुझे बहुत अच्छा लगता है. लेकिन जब मैं तुम लोगों के लिए कुछ स्पेशल बात कहता हूँ, क्योंकि सारी बात रिकॉर्ड हो रही है, उस लास्ट टाइम में उस स्पेशल बात को हमेशा ध्यान में रखा करो. जो मैं लास्ट टाइम में जो कहता हूँ, क्लास के जस्ट 2-3 दिन महीने के लास्ट में जो 2-3 बातें कहता हूँ, तो उस बात को तुम सब ध्यान में रखो और तुम भी सुखी रहोगे और हम भी सुखी रहेंगे, ठीक ना। बाकी चीजें तो ठीक है, हम लोग तो एक अपना फैमिली मेंबर की तरह हैं, चलेगा, लेकिन उस बात को ध्यान में रखो, क्योंकि मुझे खुद अच्छा नहीं लगता कि अब तुम सब इतना प्रेजेंट होते हो फिर दिक्कत आ जाए। तो इस पॉइंट को लेकर के इट मीन्स दैट बाकी तुम्हें जो कंपटीशन की तैयारी करना है, कंपटीशन की तैयारी करो, बढ़िया से तैयारी करो और सब्जेक्ट पर ध्यान रखो, कॉन्स्टिट्यूशन पे, सीपीसी जैसे सब्जेक्ट पर ध्यान रखो। और हम लोग देखो तुम लोग का नेटवर्क खराब रहता है, इसलिए यूट्यूब पे डाल भी देते हैं, क्योंकि बच्चों को प्रॉब्लम ना हो, तुम वहां से भी पढ़ सकते हो, रीड कर सकते हो। बाकी चीजें हमें बहुत दुख नहीं होता है, तुम किसी भी तरह से, तुम्हारी सफलता एक टीचर के लिए एक खुशी की बात होती है। तो ये हमारे टीचर हमेशा यही सिखाते आए हैं और हम लोग का भी यही ध्यान रहता है, ठीक ना। तो लास्ट के 2-3 दिन पर ध्यान रखा करो तुम सब। चलो आ जाओ। What was the ratio of the decision of this case? On the basis of the reasoning and discussion, the following conclusions were drawn by the Supreme Court. I have made the heading because, as you know, that with the help of heading, we can understand very easily. The point is that there were 7 ratios were laid down. How many ratios were laid down in that particular case? Total 7 ratios were laid down. 1, 2, 3, 4, 5, 6, 7. As you know, that section 4 is not much more important regarding the section 50. That's why here we are not going to discuss point number 4, but we will discuss the point number 5 and 6. And with the help of chart, I will make the evaluation. And your answer will depend on the ratio of this particular case. If you are not knowing the ratio of Baldev Singh case, you can't write the good marks. You can't get the good marks. First ratio are that duty of authorized police officer to inform the suspected person. How to read the law, how to remember the law. Always take example of human being. Suppose that you are 3 person, 4 person, you can take example. Okay, this person is a police officer. I am a suspected person. He is the my friend. He is the family member. In this way, make some circle of the human being and start to remember. In this way, you can remember. It means if you have some example in front of you, you can remember. And remembering the ratio in the vacuum, it is not possible for you. The first point is that duty to inform the police officer to inform the suspected person. Suppose that Murari is the police officer, Kapil is the suspected person. According to the first ratio, whether Murari has duty or not, whether Murari has duty or not. In this case, first ratio are that Murari, that is the authorized person, has imperative duty to inform the person that you have right. What is your right? You have option. Which option? 2 option. पहला ऑप्शन है कि या तो मुझसे खुद सर्च करा लो. If you have faith, allow me, I will search. That is the first option. Second option, if you have no faith upon me, please, I will produce you before the gazetted officer or the magistrate as you wish. You have option either to allow the police officer, okay, no problem, search me, or you can say that don't touch me, produce me before the gazetted officer. The first option is that it is a duty of the police officer to inform, because even the several lawmen doesn't know about the section 50 of the NDPS Act, because these are the special laws and only few persons are about such NDPS Act. Yesterday I was discussing with some of my friends. They were not aware about the provisions of the section 50. And reality is that even before your class discussion, I was not much more aware about the section 50. How can we expect from a poor person or illiterate person to know about the section 50? That's why it is a first duty of the police authority to inform that poor person, that suspected person, that illiterate person, that literate person, that you have 2 options. The first is that it is a duty to inform. Once you fail to inform, once you fail to perform your duty, what will be effect? I will discuss the effect with this help of this smart art. But please wait, I will take some time. The first of all, it is duty of the Murari, duty of the police to inform the couple. Second options, second class, second and third ratio is that effect of failure to inform, that is the class 1, and failure to produce, class 2. Class 1 says that you have to inform, and class 2 that the if the suspected person choose an option, please produce me. But even after choosing that option, you did not produce before the gazetted officer. What would be effect of these violation of class 1 and class 2? In case of violation of class 1 and 2, effect I will discuss with the help of class ratio number 2 and 3. First of all, simple point is that it will be presumed that it was prejudice to the accused. Tomorrow you can't take that, oh no. Mr. Murari was a professor of the criminal law, he was the teaching NDPS Act. There was no need to inform, he was well aware about that. Whether such argument will be sustainable? Never. Never you can't take that. He was the law professor, that's why there was no need to inform about the section 50. He was the law student, that's why there was no need to inform about section 50. No, you can't never take such a defense. Because Article 41, class first ratio and class 1 of section 50 clearly says that, टाइम होगा तो बता देना हो, ठीक ना? अभी तो चल ही रहा, लग रहा चल रहा होगा, 5 कितने 4:45 तक है ना, ठीक है टाइम. Yes, failure to perform, it will be presumed that that was prejudice to the accused. Okay, that was prejudice to the accused. According to according to the ratio third, this we can understand with the help of this smart art. First of all, what is the smart art? Effect of search without prior information or without producing before the authorized officer. It means here violation of class 1, that is the non-providing information, and class 2 talks about that no production before the authorized person. So what would be effect of the violation of class 1 and 2 of section 50? So with the help of ratio number 2 and 3 we can understand. Come to the ratio. First point, court said that, in this case, court said that it will not vitiate the trial. Violation of class 1 and class 2 will not vitiate the trial. This is the normal rule. This is normal rule. It will not vitiate the trial. थोड़ा स्पेलिंग इसमें देखते रहना, तुम लोग बताते रहना, कहीं गलत गलत होता रहेगा तो. The may not vitiate trial. This is the first point. Okay, it will not vitiate the trial, but what would be happen? Recovery of such goods in violation of class 1 and class 2 will be illicit recovery. It means such recovery will be treated as a illegal recovery. Although trial will not vitiate, but such recovery of goods will treat as a illegal recovery. This is regarding the recovery of the goods. Second point regarding the conviction. Whether a person will be convicted even in case of the violation of class 1 and class 2, court said that there are two parts. When such conviction when such conviction is not possible, that is when such conviction will be vitiate, and when such conviction will not vitiate. The point was that in certain circumstances, person will be convicted, and in certain circumstances, person will not be convicted. So when he will not be convicted, and when he will be convicted. Suppose that whole conviction is based on the solely only on one grounds, that is the recovery of illicit articles. इसका मतलब यह है कि illicit आर्टिकल दैट इज द रिकवरी क्या हो जाएगी, इलिसिट हो जाएगी। इलिसिट आर्टिकल के सिवा और कोई अदर एविडेंस है ही नहीं जिससे कि प्रूव कर दिया जाए कि यस ही वाज कैरिंग द कंट्राबैंड गुड्स। इसके पास और कुछ था ही नहीं। देयर वाज ओनली वन एविडेंस, that evidence was recovery of the illicit articles. As you know that such recovery is illicit, that's why his conviction is not possible only on uh, such recovery. That's why solely on such recovery conviction is not possible. But second point, if conviction is based on some independent evidence as well as illicit articles, in that case, conviction will be upheld. For the example, I made the search. I recovered cheras from the possession of the couple. And except recovery of the cheras, I have no other evidence. उस समय मैंने पार्थ कपिल को बताया नहीं कि तुम्हारे पास सेक्शन 50 के अंतर्गत ऑप्शन है। मैंने उसको गैजेट ऑफिसर के पास लेकर के नहीं गया, मैंने सिर्फ उसका तुरंत ऑन द स्पॉट सर्च किया और सर्च करने के बाद मैंने वहां से चरस की रिकवरी कर लिया। जैसे कि तुम्हारे प्रॉब्लम में है, तुम्हारे प्रॉब्लम में जो दिया गया है, तुम्हारे प्रॉब्लम में तो यही है ना। उसने क्या किया, उसको तुरंत रोका और विदाउट सेइंग एनीथिंग उसने तुरंत वहां पे रिकवरी कर लिया, ओपीएम की रिकवरी कर लिया। अब ये भी कहीं इफेक्ट में कह रहा है, इफेक्ट से दैट यहाँ पे क्या हो रहा है कि वहां पे और एविडेंस बना ही नहीं, सिर्फ और सिर्फ इलिसिट आर्टिकल का है। तो यहाँ पर क्या होगा कि दैट विल बी ट्री, दैट इज द त्रिपुरारी, जो तुम्हारे क्वेश्चन में पूछा गया है, त्रिपुरारी विल नॉट बी कन्विक्टेड। व्हाई ही विल नॉट बी कन्विक्टेड? बिकॉज देयर वाज a violation of clause 1, nothing was informed him, he was not produced before the authorized officer, so whatever opium was recovered, that opium was come under the category of recovery of illicit article. Regarding his conviction, there was no other evidence except regarding the recovery of the goods. अब मान लीजिए कि कोई अदर एविडेंस है। अब अदर एविडेंस का एक एग्जांपल ले लेते हैं। अदर एविडेंस का ये है कि जैसे कि उसकी रिकवरी जब हुई तो वहां पर हमने उस रिकवरी के साथ साथ, रिकवरी तो हो गई, एक व्यक्ति जब हमने अरेस्ट करके लेकर गया तो और व्यक्तियों को हमने अरेस्ट करना शुरू किया। जब और व्यक्तियों को हमने अरेस्ट करना शुरू किया तो उसमें से एक व्यक्ति एक्कम्प्लिस बन गया। जैसे शुरू में मिस रिया चक्रवर्ती के केस में एक व्यक्ति को अरेस्ट किया गया, 1 2 3 4 5 10 व्यक्ति को अरेस्ट कर लिया गया। 10वें मिस रिया चक्रवर्ती थी और 10वें के बाद भी 11वें 12वें 13वें मतलब 15-16 आदमी को अरेस्ट कर लिया गया। अगर उसमें से कोई व्यक्ति एक्कम्प्लिस बन जाए और एक्कम्प्लिस बन जाएगा तो एक इंडिपेंडेंट एविडेंस आ जाएगा। और सेक्शन 133 कहता है कि कन्विक्शन इज नॉट इलीगल merely बेस्ड ऑन द statement or evidence of the accomplice. It means if you have some independent evidence, on that basis merely recovery of goods illegal will not be vitiate his conviction. तो हमारे कहने का मतलब है कि जहां पे सिर्फ रिकवरी है और इलिसिट रिकवरी है वहां पे कन्विक्शन विसिएट कर जाएगा। लेकिन जहां पे रिकवरी है लेकिन साथ साथ आपके पास कुछ इंडिपेंडेंट एविडेंस भी हैं, जैसे मान लीजिए को-एक्यूज्ड हो जाए या एक्कम्प्लिस हो जाए, इस तरह के सर्कमस्टांसेस में वहां पे कन्विक्शन हो जाएगा। ये तुम्हारा इफेक्ट है, इस इफेक्ट को तुम बेटर वे में पढ़ लेना, ये तुम्हारे प्रॉब्लम को सॉल्व करेगा। अब क्लास 5 and 6 का रेशियो है, इवन ऑन दैट बेसिस व्हाट एवर आई हैव डिस्कस्ड एबव यू कैन अंडरस्टैंड। सेक्शन 50 talks about another point is that these are the point on the basis of ratio number 5 6 7. This smart art talks about the ratio of 5 6 and 7. This smart art talks about the ratio of the 2 and 3. In this way come to the ratio of 5 6 and 7. It was said that question was that whether compliance of section 50 is mandatory or directory. In Baldev Singh case, court said that we can't say that whether it is a directory or mandatory. Here, opinion was not given whether section 50 is mandatory or directory. कोर्ट ने कहा कि हम इस पर ओपिनियन नहीं दे सकते कि सेक्शन 50 जो है मैंडेटरी है कि डायरेक्टरी है, लेकिन कोर्ट ने कहा कि अगर सेक्शन 50 का वायलेशन होता है तब, अगर वायलेशन होगा तो रिकवरी जो है कंट्राबैंड एक्ट की, कंट्राबैंड गुड्स की, दैट विल बी इलीगल। यहाँ पे बताया ही कि दैट विल बी इलीगल हो जाएगा। और फिर हमने कहा कि कन्विक्शन एंड सेंटेंस ऑफ एन एक्ट बैड एंड अनसस्टेनेबल इन लॉ। अब यहाँ पर हमने बताया ही कि अगर सोलली उस पर बेस्ड है तो वो कन्विक्शन क्या होगा, वो विसिएट कर जाएगा। इसी दोनों पॉइंट का सिमिलर है और इसमें कहा गया कि ये जो रिकवरी है इलीगल रूप से, उसके लिए अलग से केस आप स्टार्ट नहीं कर सकते। अनलॉफुल पोजीशन का ये नहीं कि उसके खिलाफ एक इंडिपेंडेंट ऑफेंस स्टार्ट कर दें। So my point is that in today class I summarized the case of the Baldev Singh versus State of Punjab and some previous points. In the next class I will discuss the ratio of the uh, ratio of the here I will discuss the ratio of the Vijayasinh Chandubha Jadeja. What was laid down in that case I will discuss. Okay, after that do hard work and thanks everyone for the class.